And really, there's a couple of steps to this. The first part that you mentioned, prima facie case, the rent increase has to be above the CPI, the cost of living, simply to be able to get to court. So that is like the threshold to be able to bring an action. But the second part would be what a court would look at is, well, there is the irrebuttable presumption that a rent increase is justifiable when the amount doesn't exceed the amount in operating costs and property taxes. So what you mentioned with regard to an increase in electric rates would be part of the operating cost. So that if that was all that the park owner was looking for were operating costs plus any increase in operating costs and taxes, he would have an irrebuttable presumption in his favor because obviously as a park owner you have to be allowed to recoup your costs and your operating costs and things such as taxes.
And that's just one thing where I may just suggest in the future of the bill looking at it, because what you're saying is that as long as it increases above the CPI, the tenant has the right to bring the landlord into court. Landlord's into court and has to deal with the expenses of that, and will have to say, hey, I had a very reasonable increase. LIPA put my increases at 3%. Right. I had no choice to do it. So in essence, what I wish it said instead was that as part of the prima facie case, not only the CPI, but maybe those utility costs that, again, the landlord just cannot possibly negotiate out of. It's beyond their control. So, again, you have to throw the landlord in court, spend a lot of money, and simply saying, here's my LIPA bill, I had no choice.
But it's an irrebuttable presumption.
Right.
If you can show that, it's over. Where this becomes, where it might end up really before a judge is going to be where you have costs over and above those. That may be legitimate costs, maybe right. Capital costs. Yeah. And those are situations. But I will say this, that, this legislation that we're looking to do here in New York State has been enacted in other states, New Hampshire, Vermont, Florida. And by setting up this process, the impact there has not been a flood of litigation. Right. There's been very, very few cases that ever have been brought. But what it has done is had a chilling effect on those park owners. And by the way, I should say that the great majority of park owners are responsible small business people who do great by their tenants. But there are those that do try to exploit the situation. Right. And what it does have an effect of doing is sometimes chilling those who might want to exploit a situation from not putting forth that kind of rent increase in the first place.
I think that's a good point. And just another point of the bill, it talks about a number of things the court must take into account to determine whether the landlord had to increase those costs. On page 3, they talk about capital improvements to manufactured home park. And one theoretical thing I'll think of is there may be a chance now in parts of Suffolk you may actually get sewers like we do in Nassau County. That could be just another type of capital improvement that a landlord would have to do. Again, they'd have to defend that in court, where at the instance they may be forced to go and do those improvements as part of that increase.
Well, that's true. My experience also, and I know both on the North Fork and the South Fork, is sometimes you have mobile home park residents, homeowners, who would be glad to see those improvements if they could get and they'd be glad to pay for them if they could get the park owner to do those kinds of improvements. So, in these cases, it's not as if homeowners don't want to see those improvements done. They simply don't want to be exploited where there's no justifiable economic basis for the kind of rent increases that sometimes they see.
Thank you very much. Mr. Speaker, on the bill.
On the bill, Mr. McKevitt.
Certainly I want to laud the intent of the sponsor. Persons going and living in one of these manufactured home parks, again, their ability to move to another place is difficult, maybe impossible. And certainly if a landlord wants to gouge them with 10, 15, 20% increases, I certainly do agree with that. I just have some questions, which again, some of my colleagues may be looking to when voting on it, where I think it puts almost the landlord in the defensive position in the very beginning, whereby, again, there could be increases in utility costs or capital improvements beyond their control, and they may have to go and spend money in litigation defending in court, or maybe perhaps that should be part of the prima facie case of the tenant to show that the landlord is exceeding those amounts. So, again, just some considerations my colleagues may want to have in voting on the bill. Thank you.
Thank you, sir. Mr. Goodell.
Thank you, Mr. Speaker. Would the sponsor yield?
Yes.
Mr. Thiel yields. Thank you.
Thank you, Mr. Thiel. Would this bill apply to the initial contract rental for a new mobile home tenant as the very first contract?
No, because it's the first contract. There hasn't been an increase. Typically, these increases come, on an annual basis at one time that apply to everybody in the park. But I mean, if you're signing your initial, your initial contract, there's no base, so there's no way to be able to judge whether there's an increase.
If you have a multi-year contract that has an escalator already built into it, would this supersede the existing escalator?
If the contract, this sounds like one of those Goodell constitutional questions coming my way.
How did you guess?
Because I don't, if I've entered into an agreement already and that rent increase has already been built into that contract, into that lease, and you've signed it, I think that would be, this bill could not apply to that because you couldn't have an impact on an existing lease agreement.
I would agree with your analysis. Although I don't think your bill language says that, I agree with your analysis, and so you might want to take a look to make your bill language clear on that. What is a reasonable return on investment, and does that include an evaluation of what you could get for that property if sold for an alternative use?
Yes, certainly. What is the experience?
Ladies and gentlemen, please have some respect for your colleagues.
According to the standards that are in the bill, certainly things such as what is, what have been the going rates, what has the experience been in the community with regard to rent, certainly would be part of it, yes.
As you know, New York City has had rent control for many, many years. Yet on this floor, we typically hear of all the problems associated with that. A lack of availability, poor condition of apartments, constant tension between landlords and tenants. Why would this bill, which appears to be similar to a rent control type structure, why would this bill not result in the same types of problems? Deferred maintenance, lack of availability, and other problems that are associated when you no longer follow free market supply and demand.
Well, first of all, I would dispute the fact that this is rent control. To me, this is more akin to statutes that deal with price gouging, for instance, by providing a judicial remedy there. I think there's 2 points that I can make that, to me, demonstrate that this is not rent control. First of all, it is a judicial remedy. With rent control, typically there's a very detailed administrative process with regard to the setting of rents and things of that nature. That's not what's going on here. It's when you've got a unreasonable or unconscionable rent, it gives the homeowner a remedy. So having a judicial remedy, I think, is different than a rather comprehensive administrative process with regard to rent. So that's number one. And second is the fact that I look at the sponsorship and I see Mr. Palumbo's name and Mr. Graff's name, and I know they wouldn't vote for rent control. I mean, I may be suspect, but I know that they wouldn't. So when I looked at that, I know that this can't possibly be rent control.
Well, I'll certainly talk to my colleagues later. Thank you very much, Mr. Thiel.
Right,
on the bill.
On the bill, sir.
The existing law already provides special protections to mobile home park residents. There's a special longer-term eviction process. There's special provisions that deal with maintaining the health and safety of a mobile home park. Already special powers are given to local governments. What this bill does is replace the free market supply-demand situation with an oversight process that puts government power and courts in reviewing business decisions. This bill doesn't use the word unconscionable rate increase or excessive rate increase or any of the words that we have in our existing laws that prevent price gouging. What this says is that all the mobile home park owner can get is a reasonable return on investment, not defined by the free market, but defined by a court. And we've seen in our country over and over where government interferes with the free market system, tries to override supply and demand, and the long-term results have always been negative. And so while I appreciate the desire to prevent price gouging, and I think we already have statutes that deal with price gouging, this bill, I think, will make a difficult situation worse by discouraging the development and expansion of mobile home parks, ultimately resulting in fewer people getting the services they want. For that reason, I'll be voting against it and urge my colleagues to do the same. Thank you, Mr. Speaker.
Thank you, sir. Read the last section.
This act shall take effect January 1st.
Clerk will record the vote. Are there any other votes? Announce the results.
Ayes 95, noes 26.
The bill is passed.
Assembly 6417A, Calendar 243. Ms. Simon, an act to amend the public health law.
An explanation is requested. Ms. Simon.
Yes, thank you. The proposed legislation, which is entitled the Local Input in Community Health Act, or LICH Act, would amend the public health law to require an analysis of the impacts of a hospital closure on the community health needs and to provide for public input prior to any decision to allow closure of the hospital in a city with a population of more than 1 million or more.
Ms. Corwin.
Thank you, Mr. Speaker. Would the sponsor yield?
Certainly.
Ms. Simon will yield.
Thank you, Joanne. Yes, it's interesting. The name is the Local Input Community Healthcare Act, LICH Act, and that's the same as Long Island College Hospital, which I understand is in New York City and had some problems in recent years and ultimately ended up closing. Now, the reason they closed was because they ran out of money. And I see in your language of your bill that the commissioner would have the authority to approve a closing, meaning that if the hospital needed to close, they wouldn't be allowed to if they still were needed in the community, regardless of whether or not they can afford to stay open. So what would a hospital do under your legislation if they couldn't afford to stay open, but the commissioner wanted them to stay open?
Well, I believe we've had similar conversations about this issue in the past. And of course, if an entity is bankrupt, it has various bankruptcy protections at its disposal. It can seek and raise funding in other ways. But in reality, this bill does not prohibit the commissioner from closing a hospital. It does require notice to the community. It requires a plan. It requires that a plan provide for amelioration of the impacts on a community, and that it can't close without having complied with the statute and doing those very things that would identify community needs and address community needs.
Okay. I guess I'm confused because on page 2, lines 45 through 48, it says the commissioner may only approve the application if he or she reasonably determines that the needs of the community and impacted stakeholders, including emergency medical care, can be adequately met. So it doesn't really speak to whether or not it's fiscally possible for them to stay open. And I'm thinking in particular when you're talking about employees, because obviously a lot of the employees probably live in the surrounding areas of the hospital as well. Are they expected to continue working even though they may not be able to be paid?
Well, first let me address the first issue you raised, and that is whether or not a hospital who doesn't have any money would be forced to remain open. In fact, on page 2 of the legislation, line 7, and it's 2.4, I guess it's 2801I, paragraph 2, subsection 4, which says that part of the plan and part of the application to the department would be an assessment of the ability of the state to assume financial responsibility or to identify an alternate operator. And so that's part of the assessment that would be considered by the state by the State Department of Health in approving a plan. Now, you also asked about employees.
Right. I'm just saying that even if you go into bankruptcy protection, chances are whatever financial remedies may be afforded through bankruptcy, it doesn't happen immediately. So if the commissioner comes out and does not approve that application and says you cannot close, but it takes them a while to figure out how they're going to pay everybody, are the employees and the rest of the operations expected to continue? My read of the bill is that it would be, that they would not be able to suspend their services either.
Well, I think that if they require the hospital to remain open, they would require it to be staffed. And of course, staffing at hospitals is often subject to collective bargaining agreements, and the employers and the unions will often work out ways to address those issues. In this particular case, there were many local employees and many who were not local employees and many long-term employees as well.
Okay. And when Department of Health takes a course of action, generally they do it by revoking operating certificates or imposing some sort of fine. In this case, you have a hospital that would want to close and they're saying, no, you can't. How would they force the hospital to stay open?
That would be a procedure that would be developed by the Department of Health. The legislation doesn't address the specific procedures that the department would use were that to be a circumstance.
Okay. Thank you, Ms. Simon. On the bill, Mr. Speaker.
On the bill, Ms. Cohen.
I remember reading quite a bit about the whole Long Island College Hospital situation, and it was a tragic situation because clearly there was an urgent need in the community to have that hospital stay open. But I also attended the hearings and listened to our SUNY chancellor talk at length about the tens of millions of dollars that the hospital was losing month after month, making it impossible for them to continue to provide services to pay their employees in that neighborhood. It would be great if we could just legislate that we have whatever services we want. But the reality is, at the end of the day, people need to get paid. Suppliers need to be paid. And if the hospital isn't taking in enough money to provide that, then they have no option to close, regardless of how urgent the need is in the community. Certainly, we have a process already in place, an orderly process that allows the community, the Department of Health, and all the stakeholders to be able to weigh in and come up with a solution for what to do when the hospital closes. But having a law that says the commissioner has the authority to prevent a hospital from closing is just impossible to support. So I recommend a no vote on this bill.
Thank you. Read the last. DiPietro, I'm sorry.
Will the sponsor yield for a quick question?
Certainly.
Ms. Simon yields.
Okay,
Mr.
thank you,
DiPietro.
Ms. Simon. When if there's a situation where the hospital is going to close and they're told to stay open, is there anything in the bill that prevents what happens if the hospital says we don't have any money and workers walk out and it affects the safety and welfare of people in the hospital?
That would be part of the department's evaluation of whether or not it would approve a closure. It absolutely can approve a closure under this statute. It does not preclude the Commissioner of Health from closing a hospital, nor would it require a hospital to stay open if it was indeed bankrupt. All of this information goes into the mix, and it goes into the application that the hospital would make. The current procedures, for example, only provide notice to community to even evaluate impacts after a closure is approved. This would require notice so that those assessments of needs could be done prior to the Department of Health making such a determination.
Okay. Thank you, sir. Thank you, Mr. Speaker.
Read the last section.
This act shall take effect immediately.
Clerk will record the vote. Mr. Ortiz to explain his vote.
Thank you, Mr. Speaker. I do want to really commend the sponsor of this piece of legislation because the closure of hospitals, sometimes when they most of the time they happen, sometimes they happen in very distressed and minority community. The minority community and distressed community are the most impacted when it's come to closure. As a result of the closure of this hospital in Atlantic Avenue, one of the major things that we have to remember is that this hospital was serving the community of Red Hook. A community of Red Hook is a community of around 12,000 people, which from the 12,000 people, 10,000 people live in the development. From those 10,000 people, the average income in that particular community is about $5,000. So therefore, those folks had an opportunity to walk to this particular hospital, which was very nearby. When the closure happened, no one took those people into consideration, and those people had to go to other hospital very far away from the facility that was closure at that point. And I would like to say that this bill is a bill in the right direction to ensure that when they are going to close hospitals, that the people that are looking into the avenue to close this hospital, that they take into consideration how they impact in our minority community. For therefore, Mr. Speaker, I'm voting in the affirmative, and I would like to commend the Speaker. Thank you.
Mr. Ortiz in the affirmative. Are there any other votes? Announce the results.
Ayes 84, noes 37.
The bill is passed.
Assembly 5083D, Calendar 459, Ms. Pullen, an act to amend the Public Service Law.
An explanation is requested, Ms. Paulin.
Yes, sure.
So this bill requires the Department of Public Service to establish a uniform natural gas leak classification system.
Mr. Corwin,
Thank you, Mr. Speaker. With the sponsor yield?
will you yield, Mr. Paulin?
Sure.
Sponsor yields.
Thank you, Amy. My understanding right now is the Department of Public Service follows guidelines that are similar to what the federal guidelines are. Now, your bill specifically codifies what those procedures are. What would happen if the federal guidelines change?
Well, I think we would amend the law. The goal of the bill is to really have public what is now not known to the public, which is where are the gas leaks that they should be aware of so that they can know to report incidents. So this is, it requires really the codification in order to take that next step.
Okay, so we have types 1, 2A, 2, and 3. If the federal government comes back, with technology or whatever, the gas pipeline system changes or becomes more technological and they want to modify those, we'd have to come back here and pass a bill or?
Well, it's been like this for a very long time, and it's not very likely that we're going to see those kinds of modifications based on the history that we've seen for this. So, we've gotten no negative comments from the department nor from the utilities that would be required to implement it. So I think they also see that it's been in existence for a long time. So we don't really expect those kind of modifications.
Okay, I did see there is some opposition from the Energy Coalition, which I believe is a coalition of those companies. How does it work currently? They are required to track gas leaks and keep that information, and my understanding is Public Service Commission will review those through their audits.
Yes, but there's been a real problem, as we saw in New York City, and so voluntarily, Con Edison has done exactly this, which is to map the gas leaks so that people can be more aware of where where the variety of gas leaks are. It hasn't caused a commotion. I'm sure most people are unaware, frankly, but if they wanted to become aware and they did smell gas, they would know whether there was anything to be concerned about.
So then you're saying that the utilities are starting to adopt this
Well, we have
process?
seen one utility do it because of what was a real problem, in the city. We had an explosion. So we did see, one utility agree that this was something that could and should be done. So this is to broaden that so we don't see those kinds of real negative problems elsewhere.
Okay, thank you, Amy. On the bill, Mr. Speaker?
On the bill, Mr. Corwin.
Certainly, the sponsor referenced a terrible tragedy that happened in New York City about a year or so ago, and it was a terrible thing to happen. And unfortunately, when I was reading the stories about it, I got the sense that there are a lot of people out there tampering with gas lines as well, which is a very scary thought when you consider how populated New York City is. My concern with this legislation is the fact that we are currently here in the state following federal guidelines, but we have the flexibility to modify those guidelines based on what the federal government recommends as well. I call that a best practices process where you're able to adopt the latest and greatest technology and procedures that would, do the most good for people. My concern with this bill is that we're codifying or putting down on paper a certain system that would have to stay in place, and if technology or the future holds changes that should be warranted, we would have to go back and re-legislate, which actually creates more of a bureaucratic process and hinders us from being able to do the best practices. So while I agree with the intent of the bill, if we already have a utility company that's already adopting a process and they still have the ability to be flexible in the future, to me, that's another best practice that certainly the industry is looking into, and I think that should suffice to be able to allow us the adaptation abilities so that we can continue to provide the best services possible. So certainly if there was something in the bill that would allow us that flexibility, I would be able to support it, but in its current form, I would not be able to support the bill. Thank you.
Thank you, Ms. Corwin. Read the last section.
This act shall take effect immediately.
Clerk will record the vote. Are there any other votes? Announce the results.
Ayes 97, noes 29.
The bill is passed. Mr. Morelli.
Thank you, Mr. Speaker. Do you have any housekeeping or resolutions to take up?
Housekeeping. On a motion by Ms. Lepardo, page 58, calendar number 620, bill number 9902. Amendments are received and adopted. Numerous resolutions. Take them up in one vote. On the resolutions, all those in favor signify by saying aye. Opposed, no. Resolutions are adopted. Mr. Morelli.
Yes. Could you please recognize Ms. Schimmel for an announcement?
Ms. Schimmel, for the purposes of an announcement.
Yes, Mr. Speaker, there will be a majority conference in the Speaker's conference room at the close of legislative session. Thank you, Mr. Speaker.
Majority conference, Speaker's conference room. Mr. Morelli.
Thank you, Mr. Speaker. I now move that the Assembly stand adjourned until 3 p.m. Tuesday, May 17th. Tomorrow is a session day.
Assembly stands adjourned.